part of the record of this proceeding, and obviously I would never file them, particularly in light of this discussion we just had now in the order before. But is there some way that we can all agree or stipulate that the grand jury transcripts are a record of this proceeding, because parties have referred to them, and I believe they're part, and they may be necessary depending on who may or may not like whatever ruling you may make.
Okay. Does anybody have any objection if it were made part of the record but sealed in the court record? Anybody?
No objection, Judge. I would think that they are part of the case to begin with.
They probably are.
Yeah.
Make it clear. I would want to make sure that it's clear that if it is going to be or it is sealed.
The only thing I'd ask to include then are the grand jury exhibits, because those were presented as part of those transcripts.
Okay.
I agree, and I should have said that, and thank you for clarifying that, Mr. Clinton.
I will make the inquiry to determine whether it is already part of the record and to make sure it's sealed if it is. If it is not, I will work with the clerk's office to make the transcripts and the exhibits part of the record, but sealed within the record. Okay. All right, so now you have 4 minutes left.
4 minutes.
And for the record, we've all spent so much time together. We need to, even if it's not funny, trying to inject a little levity here. And I'm just giving the counsel for the state a hard time because of the conversation that occurred yesterday.
Oh, totally understand, Judge. Yeah. So after hearing 2 days of Nick Klingerman for the state, by the way. So after hearing 2 days of argument, you've heard a lot about things that are not actually in the text of the anti-SLAPP statute 12-751. So I want to spend most of my time covering that statute and what it actually says and does. But I have a lot of ground to cover, so let me give you an outline. First, I want to briefly comment on what the state believes are the issues before the court right now, and give you a brief introduction about what I'm going to cover. I think I need to start then with the reasoning for allowing the state to respond in the prima facie showing. In this case, I'd like to review the history and purpose of the anti-SLAPP statute. And then I want to address your questions about substantial motivation and involves. And with that background, I was hoping to get to the hypotheticals that you posed and address those as well. I then want to talk about whether the defendants have met their prima facie burden. So have they established a prima facie case that the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of the constitutional rights that are at issue. And specifically, I want to then focus on, does this case involve the lawful exercise of First Amendment rights? Then, and I apologize in advance because I'm not entirely sure how relevant it is, but there were many factual arguments made over the past 2 days about evidence that the state does or does not have. I don't necessarily think, and I don't believe they are relevant for this hearing, but I need to create a complete record given those, and I want to cover those briefly at the end. So let me kind of get to the overview. We are currently here just on limited briefing on whether the defendants have proven a prima facie claim under the anti-SLAPP statute. So the issue before this court today, does the anti-SLAPP statute apply to this case, and have the defendants proven a prima facie claim? This legal action, in other words, this prosecution, involves nothing more than enforcing the law against those who are alleged to have committed frauds, forgeries, and conspiracies to change the outcome of a lawful election because they were unsatisfied with the results. And like all criminal prosecutions, it seeks to punish prior behavior, educate the public, and deter future efforts to do the same thing. Left unchecked, this can happen again, and I'll address those arguments later too. I think this reminder is important because of all the arguments that I've heard over the past 2 days. The most surprising is the argument that the First Amendment somehow allowed the defendants to engage in fraud, forgeries, and conspiracies to deprive every citizen of their constitutional right to democracy because some people believe the 2020 election was stolen and because election lawsuits are hard. Simply put, that is not protected speech. Section 12-751 does not protect that behavior. The statute has two showings, speaking of that statute, two initial ones that are at issue here. The first, judge, is in paragraph A of the statute, and that establishes the requirements to simply file an anti-SLAPP motion to dismiss. That's whether the defendants even get their foot in the door. That requires three things, in my opinion. A legal action, which is defined to include a prosecution. We're not disputing that here. That involves, and that I want to talk about, in the lawful exercise of First Amendment rights. That's the third component. The second paragraph, which is B then, lists the prima facie showing. That requires also, I'd say, three things. Again, the prosecution, and then was substantially motivated by a desire to deter, retaliate against, or prevent. And then the third item, the lawful exercise of a constitutional right. Defendants' motions fail at both steps. First, the anti-SLAPP statute does not apply because this case does not involve the lawful exercise of certain First Amendment rights. And second, defendants have not made a prima facie showing that this prosecution is substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of certain constitutional rights.
Many of the defendants argued that many of the things that are in the indictment and that the state, according to them, is relying upon to establish the conspiratorial nature of what occurred were things like statements they made on social media, emails they sent expressing their views, letters they've written expressing what they think should or shouldn't occur. And what they argued to me over the last 2 days was, that's my right as a citizen. I can go ahead and do that.
And Judge, I'll start with those incidental things. I just want to quote some Supreme Court cases. So, yeah, you've heard the defendants single out individual acts in the indictment, which are there to show intent, participation in the conspiracy, agreements, or their motive for participating. None of that is protected speech, Judge. And I'll start with Gibney v. Empire Storage and Ice Company, which is 336 U.S. 490. And I'll just quote, "It has rarely been suggested that the constitutional freedom for speech and press extends its immunity to speech or writing used as an integral part of conduct in violation of a valid criminal statute. We reject that contention now. Nothing that was said or decided in any of the cases relied on by appellants calls for a different holding." And then you could, in Wisconsin v. Mitchell, 508 U.S. 476 in 1993, the court said the First Amendment, quote, "does not prohibit the evidentiary use of speech to establish the elements of a crime or to prove motive or intent. Evidence of a defendant's previous declarations or statements is commonly admitted in criminal trials, subject to evidentiary rules dealing with relevancy, reliability, and the like." Judge, all those statements in the indictment are to show the intent for the counts. It's not protected speech, and I just gave you 2 U.S. Supreme Court cases that clearly establish that is not protected speech. So in talking about that, whether or not it's appropriate for the state to even respond here, the statute does not preclude a response to a prima facie argument. It's silent, Judge. And the statute does not say the adequacy of the prima facie showing must be only on the defendant's motion, as in other states in not anti-SLAPP statutes, but I've seen that included in statutes as well. So the state asked for, and this court granted briefing on the issue. We made that request, even though it's not required under 751, for a few reasons, the first of which, this is an issue of first impression. But second, and I think this is most important, if the state does not contest the prima facie showing, it appears, and I use appears specifically because I believe the statute is so poorly constructed that I'm not intending to concede anything on it at this point. The state will not have an opportunity to challenge challenge the involve, the lawful requirement, or the substantial motivation requirements because none of those are relevant under 12751B1, which lists the items the state must prove after a prima facie showing. In other words, if this court mistakenly concludes that defendants have established a prima facie case, the state will never have the opportunity to rebut those issues. So let me explain why I say that. The statute does not actually say what happens after a prima facie showing. Presumably, the burden shifts to the state. In terms of the state's burden, there is none in the statute. The statute provides only that the state must quote-unquote show. And then what it requires that the state must show is one, that the prosecution is quote-unquote justified by established law, whatever that means, and two, the state, quote, did not act in order to deter, prevent, or retaliate against the defendant's exercise of certain constitutional rights. To what quantity must the state show that? I have no idea. It's not in the statute. It's anyone's guess. And then the statute confusingly omits the items that the defendant had a presumption to show. It does not discuss involves, substantially motivated, or the lawful content at all. I never get a chance to rebut those presumptions. So, and then what must the state show? It's also silent. Is it probable cause? Is it preponderance of the evidence? Is it something more? Maybe a prima facie showing? No one knows. It's not in the statute. And so for this reason alone, Judge, the Batson analogy does not fit this case, because at least in Batson, the state gets to rebut the prima facie showing. And also, a decision to strike a juror is not made by either a judge after a preliminary hearing finding probable cause, or a grand jury finding probable cause, like the initiation of a felony criminal case, which we're dealing with here. I think it's also very misleading to argue that all the statute does is say that we're just going to have an evidentiary hearing because, if something seems off, the state just has to rebut the presumption. Well, first, not only is the standard in 12751B says nothing about something being not right, it requires way more than that. But the state never gets to rebut that presumption. It's not in the statute. So as we've heard, defendants are going to argue that this case is not consistent with clearly established law because no fake elector has been charged in Arizona before. And while I dispute that is what clearly established law means under the statute, yeah, they're right. It's never happened in Arizona before. So I could rebut the substantial motivation until I'm blue in the face. But if they're right on the law, this court will have to dismiss. Or, to use the rock throwing hypo, if no one has ever thrown a rock through the legislature's window, is that not clearly established law under the same arguments? Because if so, that's not just an evidentiary hearing like you heard yesterday. The legislature's hypo would require dismissal. And I can tell you, Judge,
That's actually a question I wanted to pose for you, because you've hit on something that I wanted to hear from you on. I got the answers from others. B1 talks about consistent with prior, I don't have the exact wording in front of me. You can give it to me. The B1 standard.
For having charged this in similar cases against similarly situated individuals.
So, if I've been having trouble with the statute to understand, and it was discussed yesterday, if the state historically well-established law have charged people for filing documents, public filings that have fraudulent information or I'll stick with that.
Yeah.
I've been trying to figure out under the statute, if the prima facie showing is met, under B1, do you come in with evidence saying, we've charged other people with fraud or forgery or similar charges when they submitted a document that was false, that they had affirmed to be true, or that they submitted a false document for the purpose of it being relied upon as true, or whether you have to show that other people have been prosecuted for filing false elector documents. And if, it would seem to me if we have the narrow reading of the statute, you will never be able to meet the B1 standard because any novel charges, put aside this case, any first impression charges that everybody in a vacuum would look at and say, well, that doesn't seem like that's lawful, you would not be able to meet that standard. That's where I've been struggling is, what are they referring to there in that regard? And you've touched on it, and because I got answers from everyone else, I'm assuming you have a counter response to it.
Judge, and I can tell you the state is going to come in and argue, I've charged other people with fraud. You committed frauds, I've charged that. You've committed forgeries, we charge that. We charge conspiracies when people commit conspiracies. I think that's the evidence that you prove that count with. But as you've heard, the defendants are going to advocate for a narrow reading. And to be honest, if the state can never bring a novel fact pattern under this statute, then that's just not a rational or functioning criminal justice system. That cannot be the intent of this statute. So I want to move on then, also thinking about why we're arguing here, that if you do make a prima facie showing, here's what paragraph C says. In making its determination, the court shall conduct an evidentiary hearing or consider the pleadings in supporting or opposing affidavits, stating facts on which the liability defense or action is based. So it sounds like I could rebut that with an affidavit. If you accept that, that works. But the defendants are proposing lengthy discovery in an evidentiary hearing that simply seems inconsistent with this text and the purpose of the statute, which I'll touch on. It will substantially delay this trial. And as you heard yesterday, defendants are proposing to depose the Attorney General, her Chief Deputy, and presumably many others. Nor is that clearly appropriate at all. And as Amici's counsel did when I sent a subpoena to some of his clients earlier, he responded with the Apex Doctrine, which is a discovery limitation in federal court, saying that high-level government officials should not, absent extraordinary circumstances, be called to testify about their official actions. So why should the Attorney General, her Chief Deputy, or even me, the head of the criminal division, not fall within the scope of that doctrine? And as you've heard over the past 2 days, the procedure the defendants propose raises serious constitutional concerns. The statute is either a procedural sea change, what they've called it, or a watershed. I've heard that too. That would undermine broad swaths of the Arizona Supreme Court's constitutional rulemaking authority. We haven't had a chance to brief that yet, but I would like the opportunity if you make a prima facie showing. We've heard arguments that supplant at least Rule 12.9, Rule 13, and Rule 16.4, if not the limits of Rule 20. And the contradictions that you've heard are dizzying. Judge, don't consider the grand jury's probable cause determination, but let's look at the grand jury's probable cause determination to rebut this claim. And Rule 13 only requires notice pleading, but the indictment is too vague or charges way too much stuff. And don't consider the legal sufficiency of the crimes, but also consider our defenses, which is contrary to Rule 16.4. That clearly undermines the Supreme Court's procedural rulemaking authority. Some defendants seem to suggest that the statute creates new substantive rights, which they seek to apply retroactively, even though the statute provides that it creates no privileges or immunities. And defendants are using this case to try the merits of the defense. It also appears to violate the state's constitutional right to a jury trial in criminal cases. And
just slow down slightly.
Yeah.
Because I'm starting to smell some smoke coming.
I'll go slower. And plaintiffs, remember, this applies equally to civil suits, plaintiffs' constitutional right to jury trials as well. These are interesting arguments, don't get me wrong. I'd rather just move forward and with the case than litigate constitutional issues when defendants have failed to meet their burden. So until yesterday, which when I heard the anti-SLAPP statute was about government transparency, I thought there was no dispute that the anti-SLAPP statutes were designed to accomplish two things: to screen out meritless claims, and that's important, meritless claims that involve protected activity, and allow courts to screen those claims before the defendant is required to undergo the expense and intrusion of discovery. I have never heard reference to government transparency in any, including Arizona's anti-SLAPP statutes. Remember, again, the statute applies equally to government and private actors. There is no government transparency in making a private litigant explain the reason for bringing a lawsuit. And suggesting that this is an open government statute is simply wrong and supported by nothing in the history of the anti-SLAPP statute or anti-SLAPP statutes across the country. But the actual legislative history behind the statute confirms the policy points that I mentioned earlier. When it passed in 2006, the legislature enacted a policy statement. I've included it in its entirety on page 13 in my response to the Amici's brief, so I will not repeat that here. But you could read in that policy, the legislature sought to balance allowing legitimate lawsuits against the right to participate, to balance allowing legitimate lawsuits against defendants' rights to participate in certain First Amendment protected activities. That process was intended to be efficient. So again, meritless claims get excluded and it happens quickly. As far as I know, Judge, Arizona is the only state to extend an anti-SLAPP statute to criminal actions. That happened in 2022, but that year the legislature substantially expanded the anti-SLAPP statute. Since 2006, and the statute had been criticized as being too narrow, only applied to the exercise of the right to petition, and then that was only when it was made part of an initiative, referendum, or recall effort in certain government proceedings. That was it. In 2022, the legislature substantially expanded the statute to cover most First Amendment activities in any form. It, however, added two significant limitations on that dramatic expansion. And the first is it added the adjective lawful to the list of constitutional rights. Lawful was not in the original 2006 enactment, and it was not in the version of the anti-SLAPP statute that passed the House in 2022. It was added in the Senate Judiciary, who, according to Mr. Langhofer, who's here, to prevent, quote, it's in his testimony in the legislature, unintended consequences. We presume that the legislature does not enact superfluous legislation, so that must mean something significant to the statute. Second, the legislature also limited the statute by requiring defendants prove a prima facie case. The prima facie showing was also not in the original 2006 enactment, and again, it was not in the version that passed the House either. It was added in the Senate. And as part of that prima facie showing, not only does the lawful adjective apply, meaning defendants must show that their acts were lawful, they must also prove the prosecution was substantially motivated by that desire to deter. So while the legislature did substantially expand the anti-SLAPP statute, in some regards, it added substantial guardrails to protect an overbroad application. So you've asked about that prima facie showing. So I want to start with the statute and this substantially motivated phrase. And yesterday you've heard from other states' jury instructions on what substantially means or substantial. You don't need to look that far. In the Amici response, I cited MEIN XREL MEIN v. Cook, 219 Arizona 96, paragraph 30. That court interpreted substantially certain, and it used dictionary definitions of substantially, and it defined that to mean to great or significant extent, or for the most part, essentially. And that's on page 10 of the response to Amici. That definition is all the court needs to apply substantially motivated. So to prove substantially motivated, defendants must show that the prosecution in this case, for the most part, or essentially, was motivated by that desire to deter or retaliate against.
Are you saying that substantially certain is functional equivalent of the term substantially motivated?
I think it's different because the context in the case that I cited was in terms of intent for torts and to interpret what intent means. So you need to be substantially certain. But I think the definition, what they relied on, was substantially, and that was the part that I picked. And
The concern I have is substantially certain starts to ring in my head similar to the way we would define beyond a reasonable doubt.
I don't think
I'm
it's...
saying it goes that far. I'm saying it starts to conjure those kinds of thoughts. You're not 100% certain, but you're certain beyond a reasonable doubt. I would probably look at it and say, if they added a new standard, they would substantially certain, in my first reaction to it, would fall below beyond a reasonable doubt, maybe closer to clear and convincing evidence, something like that. That's how it falls upon me, that term. I just want some help to understand why I should apply that to substantially motivate.
Sure, Judge, and I'm not saying that's the burden of proof. What I'm saying is that that's the degree of motivation behind the deterrence, the retaliating against. So how much do they need to prove that the prosecution was motivated? Is it 1%, 100%, or somewhere in the middle? Substantially certain means primarily. And that makes sense given the history of the anti-SLAPP statutes, because remember, it's designed to deter meritless claims, claims that have no merit. So you want to make sure that you're not weeding out legitimate claims. And how do you do that? It's when somebody is primarily motivated to retaliate against you for exercising your First Amendment rights.
So I have a question then. I heard arguments over the last 2 days that said people who are otherwise guilty could end up with a dismissal under this anti-SLAPP statute. We heard numerous references to famous historic quotes along those lines. You're saying this statute was to get rid of meritless cases. They're saying, no, this could be actually a valid case against a guilty person, but if it was substantially motivated to impact their free speech, we're going to opt to protect the free speech like we would opting suppression of evidence, Fourth, Fifth, Sixth Amendment. That's a different argument than they've put forth.
Judge, I think that's wrong. I think that it's intended to allow a guilty person to walk free. And can I explain that? And then I'll work back maybe through some of those definitions. And here's the reason why, and I'll go back to why it does this. But it requires both on the initial filing, that it is the lawful exercise, and also the prima facie showing the lawful exercise of certain constitutional rights. So let me give you some examples of how to distinguish this. We talked about Surprise, the city of Surprise yesterday, and I don't know all the details, so I'm not commenting on that case specifically, but let me just pull that hypothetical the way it's presented. The defendant in that case gets cited for trespassing from City Hall for criticizing the city prosecutor. Let's say that criticism is entirely lawful under the First Amendment. We would say, then using the definition of involves that I cited in State v. Green, and I had this cite earlier in my notes, so I'll come back to that, and it's also in my briefing, that her trespassing case includes her lawful exercise of First Amendment rights because she was allowed to make that speech. And so looking at the definitions of involves that they have that's closely related to the offense, absolutely. She was trespassed for speaking. A necessary accompaniment to the offense, yes, because if the city didn't say that she was violating the First Amendment, she would have never been trespassed. And does it have an effect on the offense? Again, yes. She is charged with trespass for exercising her First Amendment rights. I would say that prosecution, trespassing, involves her right. She's not guilty of trespass because she should have never been charged at all. And the statute should kick that example. But let me contrast that with the rock thrower example, because the statute says involves the lawful exercise, and throwing rocks has nothing to do with the lawful exercise of a constitutional right. So yes, you could be speaking at a rally, but when you choose to pick up a rock and throw it through the window of any building, can I say that the throwing of the rock is closely related, the criminal damage, that your lawful, that's what the statute says, lawful First Amendment right is closely related to that criminal damage? Absolutely not. You have no lawful right to do that. Is that a necessary accompaniment to the offense, although not an element? Again, nope, you have no First Amendment right to do that. And does that, your First Amendment right to protest, have an effect on your criminal damage statute? Again, no. Is that a high burden? Absolutely, Judge. I'm not going to argue it's not. But that's what the statute says. Not only at the prima facie showing must the defendant show that it's lawful, but also just to be able to file the anti-slap statute. It's added in the statute in 2022. It means something. It means that the statute does not apply to valid claims. That means that when I prosecute somebody for committing a crime, the statute does not apply if the criminal act is what they're saying is First Amendment right. And I was going to come to this, but really, if what they're saying is that, Judge, all this is allowed under the First Amendment, and it's not illegal at all, Arizona law already provides a remedy that is faster and more efficient than this. Rule 16.4. It could be filed at any time, and it is based on the legal sufficiency of the indictment. You don't need an evidentiary hearing, which this statute requires, and it could be decided on the pleadings. So clearly, it doesn't apply.
So you mentioned about the constitutional challenge. Rule 16.4 is a creature of the Supreme Court.
Yes.
And the Supreme Court setting has, under separation of powers, the right to set procedures. We have heard here that this is a new procedural right that supplements existing rights or is in addition to. Is it your argument that the legislature, in this regard, since the same protection is already afforded, which is if it was a lawful activity, then admitting to it doesn't state a basis for a criminal claim, you're entitled to dismissal? That what they've done is they've invaded that province? Is that what I'm hearing you say? That the legislature invaded that province?
Judge, I think under the interpretation and application by the defendants, yes. Under the example I just gave with the City of Surprise example, I would say no. I want to stick with this example here to think about this in this case. This case is the analogy of the rock thrower that I just discussed, because sending false ballots to Congress with intent to defraud is no different than throwing a rock through the window of Congress on January 6th. Neither is protected speech, neither is lawful, and this prosecution does not involve the lawful exercise of speech. And so that is exactly the same example that this is not covered by the statute, because unless you interpret the statute to supplant Rule 16.4, because the acts themselves that the judge is saying as a matter of law that these are legal, then you have Rule 16.4.
Some of the defendants who were not involved on December 14th directly, they weren't there, they didn't sign anything, have argued over the last 2 days that their involvement has been petitioning the government, asking whether it's Vice President Pence or members of the legislature or Governor Ducey, or we can go down the laundry list of individuals, or, as we heard, the alleged, and I put in quotes, hearing that was conducted on November 30th that Mr. Giuliani presided over. I don't know who gave it the term hearing, but I don't know that it was a hearing. I don't know under what authority, but that's not for me to quibble about. This is a hearing. Maybe that was too, but they're saying that was my speech. Mr. Giuliani, as he has, through his attorney, acknowledged, he could have been lying about all of it. 14,000 dead people or whatever it was. He had the right to go ahead and do that, which, by the way, I concur with.
Sure, I do too, Judge.
I would disagree to my last breath, but I would do it in the same vein as him expressing it, which is I would have the right to tell him why he's wrong, and he'd have the right to even continue to lie to me if he chose to. But their acts that you are talking about were not sending false ballots to Congress. You'd have to show that they were part of a scheme or a plan for that to occur. But a lot of the things that were cited to support their link to this scheme was their free speech.
And Judge, I think that's a good point. And so I have a Sixth Circuit case. It's kind of scroll back to one, that's I don't want to lose it. But conspiracy itself is not protected speech. And I talked about the speech necessary to prove conspiracy, Mitchell and the other U.S. Supreme Court case that I referenced. So again, to prove intent, motive, participation, that's not protected speech. I still have the burden to show the intent to commit the underlying crime, the fraud, the forgeries, the fraudulent schemes and practices. So I have to show that, and that's in the indictment. They're charged with those crimes as both accomplices and co-conspirators, and then the speech necessary to prove that is not protected speech, and that came from 2 U.S. Supreme Court cases that I cited to you earlier. So, well, yes, Mr. Giuliani had every right to hold a fake hearing at the Hilton on November 30th and say that thousands of people in Arizona fraudulently voted in the election. But what he did not have the right to do was make those statements with intent to commit a fraud. And that's what he's charged with.
The fraud.
So the fraud...
And I'm not declaring the truth or lack of truth of the statements. I'm just using it in the vein that his attorney did, which is it could be a lie, it would be protected.
Yes.
But what was to the fraud perpetration? To mislead the public, to get them to think differently, leading to the 40% or so of people who think that the election was stolen? Or was the fraud an actual act?
So, Judge, so the fraud is the actual act, and that is the fake elector scheme. And so that is sending in false ballots to change the outcome of the election, purporting to be legitimate and valid, that they could be considered by Congress. And that is to basically trick the American public, or to change the outcome of a lawful election. And so Mr. Rudy Giuliani is charged with being basically the person, according to evidence in the indictment and statements from witnesses, as a person who coordinated that entire plan. There's emails having Rudy Giuliani, for example, emailed Boris Epstein to have the ballots in Arizona prepared. The ballots that the electors in Arizona used in this case, the forged ones that they're charged with, that request was, per the mayor in the email from Boris, to unindicted co-conspirator number 4 to prepare those ballots, and those ballots were then sent to Kelly Ward, and those were what were used and signed and mailed to Congress. So there is an act. He's the one that managed the whole thing.
What was the alleged act on the part of Mr. Meadows in that? Because Mr. Meadows, aside from what's going to be done in federal court next week, which has nothing to do with here, he, in that situation, was, I believe at that time, he was chief of staff for President Trump. And what's the act? Explain to me what you're alleging to be the act versus speech from Mr. Giuliani.
Yes.
What would be for Mr. Meadows?
So Mr. Meadows also worked to implement and execute that scheme, and I'll just take his own language from it. So on December 6th, Mr. Meadows receives a memo from Kenneth Chesborough outlining this plan. He gets a text from Senator Mike Lee, who wrote on December 8th of 2020, and here's the quote: If a very small handful of states were to have their legislatures appoint alternative slates of delegates, there could be a path. Mark Meadows responded, quote, I am working on that as of yesterday. On December 8th, a journalist, Woody Jenkins, texted Mark Meadows, quote, I recommend the Trump electors from AR, MI, GA, PA, Wisconsin, Nevada, I don't think he realizes Arizona is not AR, will meet next Monday at their state capitals, call themselves to order, elect officers, and cast their votes for the president. Then they certify their votes and transmit that certificate to Washington. Mark Meadows responded, we are. Mark Meadows was part of the planning and implementation of this fake elector scheme as well. That's why he was charged in the indictment as a co-conspirator in their forgeries. Text messages prove it, And then later in December, he held meetings at the White House with PowerPoints outlining the congressional plan to implement the scheme in Congress.
Well, that's the allegation, but you did answer my question about what I'm really concerned about, the difference between speech and acts, as I have focused throughout this process. I may be wrong, but at least I'm consistent. And it does concern me that there's a lot of support for the allegations are based on things that people have said. And while I will repeat again, I could fight to my dying breath how wrong they are, but I will also fight to that same breath their right to be wrong and to express that. And this case goes to that core issue. And maybe I got overly injected with the Constitution, but it's who I am.
Judge, and I don't think you are overly injected with the Constitution in terms of, but conspiracy itself will always involve speech. That's the nature of the offense.
I'm not differing with you there. That's why I'm asking you questions about acts.
So
you have at least, whether it's true or not, you've at least answered the question as to Mr. Giuliani and Mr. Meadows. I'm trying to distinguish between those who signed the document, where that's the act you're alleging.
Yes.
Whether that act was contingent or not criminal under 16.4, as Mr. Lehman has argued, I have to address that issue separately. But there's other people that are charged with a lot of reliance in the indictment on things that they publicly said. So that's where I have to at least look at this and have some level of concern about your issue, which is the lawful right component.
So, Judge, I think, and I've heard your questions in terms of the 11 electors, and you distinguish between them, but we all know they signed a document and sent it to Congress. Either, one person sends it, I get that, but collectively, accomplices, they signed it, it gets sent to Congress. I could talk more about that in a minute. So I'll skip them because to focus on the acts, let me talk about the people that didn't sign. Mr. Eastman, so he wrote a memo, now I'm not just saying only a memo, but he outlines the scheme and quote, he recommended that Pence refuse to count Arizona certified Democrat electors because, quote, there are multiple slates. Again, not a contingency plan. But it's not just that he wrote the memo, Judge. He goes to meet with the vice president's chief counsel to encourage the vice president to actually implement the plan. That's an act. He did that. That is part of the indictment. It is listed in there, and it's part of the state's evidence. Mr. Epstein, he sent the emails to allege the slates, to get the slates set up, to coordinate with unindicted co-conspirator 4. He was basically the go-between with the number to plan with Mr. Giuliani to kind of plan and implement the scheme in each of the 7 states. And he's on emails doing that. Those are acts by Mr. Epstein, sending out ballots and those requests. Christina Bobb, you've heard that she was indicted for being a journalist, but we have emails from her too. In New Mexico, as part of the scheme, the person that actually hands the Arizona electors the ballots, the day earlier, because they felt that they needed a lawsuit, she and that Trump's legal staff refused to sign that lawsuit in New Mexico. She coordinates having that same person who handed Arizona's electors the ballots, she was the one to get him to sign that lawsuit, even though I don't think he ever read it. Who knows? I guess it doesn't matter. But she actually took that act. And she had frequent, and I know from Kelly Ward's phone calls, had phone conversations between November and January of 2021, November 20 and January 2021 with Kelly Ward. And in December, she had emailed Karen Fann supposed evidence of election fraud in an attempt to get the legislature to adopt the Republican elector slates. Those are all acts. And I do want to address something, saying that she was never in Arizona, that somehow I presented false or misleading evidence to the grand jury. And we have never, until Mr. Jacobs said that, heard evidence that she was in Arizona. We believe she was. Just a few weeks ago, we interviewed Karen Fann, who told us she thought Christina Bobb was in a meeting with her. So that's news to me, if that's the case. And you've heard also some evidence about about her intent, about Mr. Yanowski's opinion about her involvement, well, following that was an instruction to the grand jurors that they have to make assessments based on the evidence, not the intent. That was omitted yesterday from the presentation of that grand jury instruction. In terms of her, you also heard that she was a journalist. I can assure you she's not indicted for being a journalist. And Mr. Giuliani, in his deposition, said that she was part of his legal team. And I just talked about his acts and that she helped implement it. Now, after the indictment, he made statements on his podcast saying that Christina Bobb was the main person in Arizona. He knows nothing about Arizona. I don't think that's going to be admissible unless he ends up testifying on behalf of the state, and I doubt that's going to happen. But it just goes to the point. She's indicted for being Mr. Giuliani's on the legal team, not being a journalist. But you don't even have to take Mr. Giuliani's words for it. You could take her own words. And that is from text message or direct messages in Twitter. Jenna Ellis, in November 2020, had sent her a message. Hi, Christina. The legal team is wondering if you are available to help. Can you contact me at jellis@donaldtrump.com with your best contact info? And then Christina Bobb responds, sorry, I just saw this. So excited to be on the team. Keeping it under wraps, though. Can update you next time we talk. And we know from her own statements that she engaged in acts on January 6th, following the violence and insurrection at the Capitol, where a police officer died, others were injured. Bob writes another person on Twitter, I'm here with Rudy, we are safe, it's not over, working lots, but nothing has been certified. The fact that the votes weren't, it's mistyped, but you can tell it's weren't, counted is good. We heard it's a contingent, but yet no lawsuit was successful on January 6th. There's an insurrection, and she is working with Rudy Giuliani to still try and have those ballots adopted at Congress. Those are her own statements. And you also heard that she was indicted for a video. The video was evidence of her intent. And so, and that was a video that she made on a broadcast network, but she was working for Rudy Giuliani's team at the time. I just quote the video. You could see that it's evidence of intent, which is allowed under the Supreme Court cases that I mentioned. Quote, if Donald Trump didn't have something, Joe Biden would be the president-elect by now. He was certified in Arizona at this point. The Trump team is challenging everything in court, as it should. But I have a suspicion that there's a whole lot more going on that hasn't reached the surface. The tide has turned and Democrats are scrambling. Their little coup has failed. I don't know how much longer we're going to have to endure the ridiculous narrative that Joe Biden is the president-elect, but what I can tell you is that it will come to a screeching halt very soon. Because she knew the plan. She was working on it. That's a statement of her knowledge and intent right there. That's the evidence. That's why that's included. That's why that was presented to the grand jury. Mike Roman worked on the ballots as well for the fake electors across the country with unindicted co-conspirator 4. And so when Pennsylvania was concerned about not having contingent language in its ballot, he texts unindicted co-conspirator 4, texts Mike Roman that he would, quote, help drafting in a couple hours, to which Mike Roman responds, fuck these guys. It's supposed to be contingent. He didn't want it added to Pennsylvania's ballots that he was working on with other unindicted co-conspirators. And I've talked about Mark Meadows. So I've covered the electors, but when I talk about the electors, and I want to dispel this notion somehow that there's a lawsuit in the indictment, that I'm prosecuting people for a lawsuit. Give me 1 second, Judge. I just want to find it. And that's Gomer v. Pence. Because a lot of this and what you've heard is, well, all of this is contingent. Gomer v. Pence, the state isn't prosecuting them for this lawsuit. It's not a violation of the First Amendment to use this lawsuit as evidence of intent. So let me explain what I mean. And on January 21st, on December 21st of 2020, before that lawsuit is filed, Kelly Ward emails all 11 electors. Yes, she included herself in that email. And it's not that long, so I'll just read the email. I was just contacted by Sydney's team, that's Sydney Powell, who filed the lawsuit. We want to file a new suit in D.C. court to assist VP Pence in his ability to follow the 12th Amendment when elector slates are presented to him on 1/6/21. Arizona has a statute that Dems will try to use to say that VP must recognize the likely fraudulent Dem slate via 3 U.S.C. 15. These statutes cannot trump the Constitution. In order to accomplish this, we will be suing Pence in order to allow him to accept the correct electors. We want to file this ASAP. Please reply to all to let us know that you're in or not. If you have questions, contact Alex Kolodin, list his number, or me, list that number. In case you haven't heard, I've already crossed my Rubicon, point of no return on this. I'm all in. The reason now that gets cited is because they filed that lawsuit. All 11 Republican electors sued in a declaratory action under 3 U.S.C. 15 to have that declared unconstitutional so that Pence could accept their vote. The complaint, which was signed, again, all 11 electors are plaintiffs on that, and I'll just quote from it. First, the events of December 14th, 2020 gave rise to two competing slates of electors for the state of Arizona. The plaintiff Arizona electors, supported by Arizona state legislators, as evidenced by December 14th, 2020 joint resolution, and the participation of Arizona legislator plaintiffs, who cast their electoral votes for President Trump and Vice President Pence, and one certified by the Arizona state executives who cast their votes for former Vice President Biden and Senator Harris. That complaint goes on to request declaratory relief, declares that Vice President Pence, and this is a quote, in his capacity as President of the Senate and presiding officer of the January 6, 2021 joint session of Congress, is subject solely to the requirements of the 12th Amendment and may exercise exclusive authority and sole discretion in determining which electoral votes to count for a given state. And by the way, Judge, that declaration, it was fake. Rusty Bowers confirmed in his interview, which is disclosed to defense counsel, there was no legislative declaration signed on December 14, 2020 because the legislature wasn't in session. And it's not even signed by enough members. It's mostly signed, about 50-50 I'd say, by actual legislators and legislators-elect. Two of them who are charged in this case. But let me read that. Because on December 14th, the day they voted, this is what the declaration says. Quote, the legislature is required to exercise its best judgment as to which slate of electors the voters prefer, and requested, quote, that the alternate 11 electoral votes be accepted to, that's a typo in there, Donald, in the actual document, Donald J. Trump, or to have all 11 electoral votes nullified completely until a full forensic audit can be counted. That's in the indictment at page 53. Judge, if we are solely operating under the ECA and these ballots are inherently contingent or that they were intended to be contingent, there's no reason for this lawsuit. Instead, the contingent defense is simply not true, Judge. And the reason that Gomer v. Pence is included in the indictment is that it's those stubborn facts that prove the ballots were not contingent, that the electors tried to have them used. And it's common sense that you don't try and use something that's inherently contingent, then why sue to have them accepted at all? And it also undermines the argument that I heard on Monday that I have no claim that the defendants discussed. To be clear, the indictment is full of discussions between the defendants. What I said and what I don't know is exactly that Jim Lehman talked with what Jim Lehman and Kelly Ward discussed during the phone call that Jim Lehman says before he voted on December 14th, where he says she called it a contingency. I have disclosed Kelly Ward's cell data records. I can't find a call to Lehman in early December. I have 3 calls on November 11th. I have 2 text messages on December 19th. And yesterday you heard argument that Mr. Lowencheck had no idea video that Jim Lehman did on January 6th, I can tell you that he had 3 calls with Kelly Ward that day, who, again, after the Capitol riot, posted on Twitter, quote, "Congress is adjourned. Send the elector choice back to the legislatures." But sure, Judge, these are inherently contingent ballots with no legal significance. And then you also heard yesterday...
Who was that last quote attributed to, Mr. Lehman or Ms. Ward?
Ms. Ward. And Jim Lehman, I don't know what he talked to her about on January 6th.
How does that link Mr. Lehman to anything that happened on January 6th?
Well, no, it was just basically showing that he's communicating still as part of the conspiracy with members of the conspiracy on that day.
But you're making an assumption that their communication was about something other than their right to talk to each other.
Absolutely, Judge.
Okay.
And so, then you've heard also that the argument that it can never happen again. Well, the lawsuit was to have the ECA declared unconstitutional. But it's still never been decided. It absolutely could happen again. It just takes another group of plaintiffs to sue to have the ECA declared unconstitutional, and you could be in the cycle where you have dueling slates of electors because somebody claims that there's election fraud, sending in ballots again. I want to get back to, and I know I wanted to cover, let's see how much time we've covered. I want to address, I think it's most important to use some of my remaining time to discuss your hypotheticals. Give me 1 second.
The amicus hypothetical?
Well, I think the ones that you had also asked about. I don't think that's the case. Let's talk about the speeding hypothetical from yesterday with the mega bumper sticker. I'm not even sure speeding applies under the statute. And let me tell you, it's not a prosecution if it's civil. In the definition of legal action, any civil means is defined to mean any civil action, claim, cross-claim, or counterclaim for damages or other than nominal damages. I don't know if a traffic ticket counts as a civil claim for damages.
What if it was 30 miles over the speed limit, which is defined to be criminal speeding?
And so I think that is a better example. So let's say you do have criminal speeding. I go back to that definition of involves and prosecution. I think those are 2 key components there in that hypothetical. So remember, the prosecution must involve the lawful exercise of First Amendment rights. Speeding and getting pulled over with a bumper sticker fails for 2 reasons. First, criminal speeding has nothing to do with involving First Amendment rights simply because you have a MAGA bumper sticker on your car. It doesn't involve lawful speech. And the police officer's decision to pull somebody over is not a prosecution. That's a decision to pull somebody over. But remember, the definition of the statute includes a prosecution. This is the actual case. Let me take a couple examples to illustrate this point better. Let's say that a cop pulls over 2, same fact pattern, criminal speeding, 2 competing cars, recognizes one of the cars as having gang members in the car. Again, implicating potentially the right to associate. And the cop thinks there's more likely that gang members may be committing other crimes in the car he doesn't know before. Does that mean somehow that the anti-SLAPP statute applies to that because the police officer made that decision? Let's say that the gang member, when he stops the car, who's a prohibited possessor and has a gun. Does that mean now that I can't prosecute that case because the cop thought that a gang member may be more likely to commit other offenses, potentially implicating that case? Absolutely not. It is not the prosecution, and that does not involve the exercise of First Amendment rights. But how far down that line do you go? Let's take a fraud example where the victim comes into my office and claims that he wants to report the case only because of the defendant's religion. And if I look at the case and find that there is a legitimate fraud, am I now prohibited from prosecuting that case because of the complaint? It's no different than the cop making that citation. They're both referring it to my office to prosecute.
So You're focused on the word involved in this
I
kind of
am in that context.
substantial motivation.
Correct. I'm thinking just to even file the complaint. But let's take another example. Let's say that you find somebody in criminal contempt and refer that case to my office. Is now your motivation in referring the case to my office implicate their First Amendment rights and that involves the prosecution? Absolutely not, Judge. It's the prosecution must involve the lawful exercise of First Amendment rights. That's what the statute says.
Were to stand in this courtroom and use expletives in talking to me, and I were to say, you keep saying that, I'm going to hold you in contempt, and I elected to pursue criminal contempt
Yes.
rather than civil.
Yes.
That person then says, this was an infringement of my free speech.
Yeah.
What happens in that hypothetical?
Well, you're defined as a state actor under the statute. So could they raise an anti-SLAPP claim against you? You would refer the case because we would have to prosecute it. But I don't believe that's at all the case. You're just referring it to me for prosecution. And then the prosecution...
Aren't you then charging them for they're going to claim, you're charging them for the expression, the involved part. I'm not talking about the...
Oh, the involved, oh, yeah. So, Judge, I would say if that is truly lawful, like, you know, that he can't do that, I don't think he can, then it does not involve the lawful exercise of First Amendment rights. And that's the plain language of the statute. It's right there in paragraph A. That lawful was not in the original statute. It was added to narrow this statute, and it does so substantially. If the legislature thinks that it got it too narrow with that, then that's for them to fix. Let me talk about, then let's go back to this 2 sets of fake electors. Yeah, there were other people in Arizona that mailed in fake ballots. And will I dispute the argument that using a fake document is not circumstantial evidence of intent to defraud? On its face, we wanted more evidence in this case for the reasons that you discussed because of the potential First Amendment. I've seen no evidence, not a shred, that the other people in Arizona who that mailed in fake ballots actually tried to have them in any kind of effort adopted by Congress. It was, to use the governor's example, a stupid political stunt. There's no intent to defraud. So if you take Mr. Binhack's analogy from yesterday, he didn't catch 2 speeders, he caught 1 speeder, the fake electors. The other person driving was going the speed limit. The other group that sent in ballots without intent to defraud. You asked about campaign statements, so let's talk about those. Take an example during the last election, and I'm sure every candidate for Attorney General discussed prosecuting cartels. One of the candidates wrote an op-ed stating that Arizona needs a cartel prosecutor, and I'm guessing that almost every county attorney in the state has made similar statements at some point. That could potentially implicate freedom of association. You could be a cartel member, you can't commit crimes as a cartel member. So does that mean now that every cartel prosecution for money laundering, gun trafficking benefits fraud? And you name it. I mean, the Attorney General must prove that the prosecution was not motivated by a desire to retaliate or prevent crimes from the cartel? No. It's a campaign statement. This is there is a distinction between saying that you want to prosecute the cartel for committing crimes and you want to prosecute the cartel for existing. And that distinction may be minor, but it is critically important when assessing substantial motivation.
Anticipating what might be said in response, cartels refers to groups of organizations designed for certain purposes. So change this and say they're going after the Smith cartel.
Or I could take an example. Let me just quote an actual statement made by somebody running for county attorney in this election with the Gilbert Goons. So let's talk about that one. The biggest thing is the difference in experience because I actually have been a prosecutor. I'm ready to come to the county and let people know that the Gilbert Goons will be prosecuted. Can that person now, if that person becomes county attorney, prosecute the Gilbert Goons? Absolutely. It's common sense that that is not a statement made to infringe on the right to associate, but it is to prosecute them for committing crimes, or it's just simply campaign speech that says nothing about what that person will do as county attorney. I think common sense dictates that candidates for office talk about these groups of people to prosecute crimes because that's what prosecutors do. And the presumption of regularity that applies to prosecutions exists because we are executive branch officers that took an oath to uphold the Constitution and laws of the state, and to presume somehow that we are prosecuting people in violation of that oath does infringe on separation of powers. And that's why you see in our briefing that the Supreme Court applies the probable cause standard to assess whether or not there's a showing of retaliatory prosecution, vindictive prosecution. I think there's an argument for that as well. But in terms of that evidence, let's actually talk about that, because yesterday, about campaign statements, that you heard from defendants that two things were not covered by the statute. Campaign statements made about groups in general, I'm going to prosecute the cartel. Agree, you've heard, not covered, right? And the attorney saying, I'm going to, the AG, in the statements that have been provided, said, I'm going to investigate those who engage in threats and intimidation against democracy and open elections. That's just a group of people. It says nothing about this case. The other one that you said is campaign statements made to investigate a specific group. Take a look at the evidence actually provided by the defendants. And I'll just read one of the examples. Quote, I would have immediately investigated the fake electors as Attorney General. There is no mystery about what happened here. The fake electors videotaped their crime for all to see. Doesn't say she's going to prosecute them. It says investigate. That, and again, it's a campaign statement. The only reference to prosecuting the fake electors was attributed to Dan Barr. That was it. And that was made before he was even a public officer. It was made on August 22nd. So if one tweet by one person not even working as a public officer is sufficient to show a prima facie case under this statute, then everything could be challenged, Judge. That is not substantially motivated. It is not evidence for a prima facie case. Let me talk about, there's a couple other things. There was this claim somehow that we are politically motivated in prosecuting the right to assemble, that there's a specific animus against Republicans. So let's actually talk about the facts of the case, the facts, not just allegations, because Arizona law requires more than mere allegations to establish a prima facie case. So the fact is that the state asked the grand jury to consider not indicting more Republicans than the grand jury actually indicted. The state asked the grand jury to consider not indicting Donald Trump, and that fake legislative declaration that the grand jury wanted to indict legislators about, the state asked them not to indict them as well, saying, quote, give them the benefit of the doubt. And for some reason, Mr. Jacobs rattled off the list of the grand jury's targets yesterday. I know a number of those people are Republicans too. And as I pointed out in response, I also told the grand jury that there was not sufficient probable cause to charge some of them as well. Now, Mr. Hoffman counters that these facts show that the state somehow guided the grand jurors to specifically indict the defendants. I mean, that's just undermined by the facts of this case. If you look at the grand jury transcripts in April, particularly April 15th, 22nd, and 23rd, we had lengthy discussions with the grand jury over the indictment. They directed me, they did, not me, not in my draft, to add the unindicted co-conspirators. They then asked if naming an unindicted co-conspirator would later preclude a prosecution. We even discussed grammar with them. During those conversations, I repeatedly took guidance and deferred to them. It's very apparent from the transcripts, and any suggestion to the contrary is just flat out wrong. Let me just read a couple of quotes. Here's how I closed the discussion on Trump and the 28 members of the Arizona legislature. Quote, but ultimately, I don't want to make you, I can't tell you how to deliberate or decide a case. That's in the April 22nd transcript at page 107. Take, for example, again on April 22nd, in response to questions, I explained the indictment to the grand juries, the way we structured it with the defendants. I kind of broke this down between the electors. I think there's a category of people just seem to fit, end quote. And then I went on. The other people that were part of the conspiracy, because we talked about it being very Arizona focused to begin with, and we did. And then I continued. But I think you take a look at the evidence that we have and the information that I was receiving, we expanded beyond, I think, just the Arizona focus draft based on your feedback. That's what I told the grand jury. That's on page 110 on April 22nd. More specifically, I never told them that they couldn't indict 28 members of the legislature or Donald Trump. We discussed evidentiary concerns with the January 6th report, which they had in evidence. We discussed the DOJ pettit policy. In terms of that policy, the third element was whether Donald Trump committed a crime in Arizona. I told the grand jurors, quote, I do not want to shade any analysis that you would have on that third point. I think that's a determination for you. And for the 28 members of the legislature, it was very focused on intent to defraud. Here's what I told them. I would be very cautious finding an intent to commit fraud with all 30 members that signed that. That's on April 22nd, again, at 1:03. Hoffman contends that the state could have dismissed the prosecution, but I don't think it's appropriate for the state to dismiss indictments issued by a grand jury when there's probable cause for those charges. But yeah, I still had multiple discussions with the grand jury about that on April 9th at 1:18 and on April 22nd at page 119 as well. I told the grand in questions about that, I told the grand jurors, quote, I don't think we would make wholesale changes or very large changes to any indictment that you would choose to issue. It's a really narrow, thoughtful discussion. And so yesterday I heard that this prosecution was ruining the lives of people, as if that's somehow relevant to this motion. But whether you're poor and unknown or rich and famous, felony charges substantially affect everyone charged. And I can tell you that the Attorney General's office believes the law should apply to all people equally. And I even told the grand jury that. So when asked if the grand jury could, quote, err on the side too many, if they were to err on the side of charging too many people, if I would, quote, have the flexibility to take one or two off, should you believe that it's not warranted, that's on April 9th at 1:19, I responded, quote, stick to, probable cause and be cognizant of it's still significant to charge somebody with a felony offense. So the allegations that there's some kind of animus are simply not true. And they're not supported by the actual evidence in this case. I want to talk about, so why should the court rely on the grand jury's probable cause finding? Because there's actually a textual reason for it, setting aside the significant constitutional reasons. Now, remember that this statute applies to legal actions, which is defined to include prosecutions. And a prosecution is a criminal proceeding in which an accused person is tried, comes from Black's Law Dictionary. The text of 12-751 states, quote, legal action was substantially motivated by a desire to deter. Well, whose desire to deter? If we were talking about a civil case, we'd be talking about the person who filed the complaint. The same if we were talking about a misdemeanor complaint, we'd probably be talking about the prosecutor or maybe the prosecutor's boss that directed them to do it. But in the context of a felony case, the person who authorizes the prosecution is the grand jury by finding probable cause, or a judge by finding probable cause. It has to be relevant to this court's determination. And I think it would be particularly problematic to ignore that probable cause finding. A grand jury testimony is done under oath. Defendants have a constitutional right to a grand jury transcript. And in this case specifically, Mr. Hoffman wrote an 18-page letter with 12 pages of attachments to the grand jury, essentially making the same allegations that he makes here, including both of his claims of a political prosecution and of First Amendment violations. In response, several grand jurors repeated their independence on the record, and I'll just read one statement. Quote, I hope the author knows, to quote this sentence here, the grand jury...
I'm here to get the bird seat. Oh, okay. All right.
The grand jury must exercise its independent judgment and its authority and right to determine what evidence to consider. We are. You can relay that message. That's April 8th, page 10. I have repeatedly told the grand jurors that they control the investigation. I've given you all the sites in the briefing. The state repeatedly reminding them that they could choose to indict no one. I gave you that in the briefing. And bringing this all together, I think the prima facie showing is that it requires the absence of probable cause when you're dealing with a felony complaint issued by an independent grand jury, and that the defendants must provide some credible evidence showing that there's a reasonable likelihood that the prosecution was substantially motivated by that desire to deter.
You said it's defeated by a probable cause finding.
Yeah.
If there is no criminal case, if there isn't a probable cause finding. Right. So I'm trying to figure out what purpose this statute would have for an alleged defendant who doesn't end up getting charged because, or they could be charged, and it could be through a probable cause hearing and a judge finds there isn't probable cause. So it could be an information, but once there's a finding of no probable cause, this statute becomes a nullity under your reading of it.
I don't think so, Judge, and let me give you two reasons. One, I've already talked about where there's an incidental, so like probable cause for trespassing is different. I think I need that clarification. When you're saying that the actual acts themselves are the retaliation, like in this case, then the probable cause finding is saying that how can you get past the lawful determination when it's been issued by a grand jury without trying the case? I think it's more, let's take the surprise example. Let's say I issued an indictment for that woman for trespassing, right? There's no probable cause that she had lawfully exercised First Amendment rights. It's probable cause determination that she was where she shouldn't have been. I think those are two different inquiries.
She'd been told that she either leaves, she was put on notice, there was a legal basis for her, for somebody to say she shouldn't be wherever she is. Like if we're in court and it's 5 o'clock and we're locking up the building, we tell somebody they have to leave and they say, I'm doing a sit-in. If you don't leave, you're going to be arrested.
I think that's different. So to make it clear, trespass, probable cause for trespass. In this case, and that's not saying that trespass is authorized for the First Amendment. No one's saying that. But there's no probable cause finding that the act, the First Amendment, was lawful in that case. But in this case, where you're saying the fraud is authorized by the First Amendment, there's a probable cause finding that it's not lawful.
Who would be in the room in front of the grand jury to say, wait a minute, yeah, they're claiming I was somewhere that I've been told I cannot be, and if I don't leave, I would be violating the law.
And I would say for the...
Who would be there to tell them, wait a minute, I was exercising my free speech?
I would say for the trespass case, where it's incidental to the charged crime, the probable cause finding is not relevant. Where you're attacking the actual charge itself is the same act that you were saying is lawful, that probable cause finding must be relevant. It just can't simply be ignored. I think that's a difference. And
I have another question. Go ahead, but finish your answer.
I was going to say also, it's perfect for the complaint scenario, right? There is no independent finding of probable cause. I'm issuing a complaint.
It's a bad example because you don't indict people for trespass generally.
No, you don't. But I think a complaint scenario is perfect for those. But I think, to get to that point, Judge, I think it's different when you're saying that the free speech is incidental to the charge. The probable cause finding is really irrelevant. When you're saying that the free speech that you're charged with is that you're basically engaged in lawful, the charges as a matter of law fail, which is what you have arguing here, you got Rule 16.4. Probable cause kicks this. There's a number of reasons. If you think the grand jury was somehow biased or unfair or impartial, you got Rule 12.9. And if for some reason I shade that grand jury in such a way that they are not impartial, then maybe that applies in the statute. I'd be hard-pressed that you could find that in this case.
So let me make a distinction of what I just heard you say. I thought you said the finding of probable cause then eliminates the application of this statute,
In this case, yes.
in this case.
Where they're attacking the actual charges themselves directly.
But then you said the finding of probable cause should be considered. So I'm trying to figure out, is it preclusive or is it relevant? Do I just deny this, saying, well, the grand jury has spoken, folks, on this case? I'm only talking about this case.
Yeah.
Or do I say, in considering this notion of whether it was a exercise of a lawful right, and it involved the exercise of that lawful right, the finding of probable cause is relevant to that question. Just trying to see which argument, which needle you're trying to thread there.
And so I struggle a little bit with that, and the only reason is because then you start butting up into Rule 16.4, right? It's a legal determination. And
that's a concern I have about the statute, is trying to figure out what was this statute designed to fix that didn't already exist.
and Judge, I think it was designed to fix the surprise example. It's the perfect setup if you use that hypothetical. But because she should have never been charged. The guilty person doesn't walk free because of this statute. She should have never been charged in that hypothetical because she was only charged for engaging in her First Amendment rights. It is the history and purpose is entirely consistent with why anti-SLAPP statutes exist. You allow legitimate defamation claims to move forward, but illegitimate, meritless ones to be quickly dismissed. How can you say that this is illegitimate when an independent grand jury issued the indictment? And it's definitely really hard to say that it is substantially motivated when an independent grand jury issued the indictment. In most instances, I think the challenge is, how do I thread that needle? Do you consider it here? Well, and I struggle in this case, Judge, because the arguments are essentially, as a matter of law, the indictment fails. Well, that's Rule 16.4. And yes, you're not going to consider the probable cause finding there. You're going to make the legal determination because that's a legal analysis. And I think, so that's where I really struggle here in that initial stage, like how do you parse that? Defendants, for some reason, are using this statute to try and backdoor Rule 16.4 argument.
This is something that I've been struggling with. Yesterday, and I don't know who to attribute to, somebody made a comment that it's even possible that this very legislation was drafted in contemplation of this very case.
Yeah, Mr. Bailey.
Okay. That is certainly possible. It's not my job to crawl into the head of the legislators who supported it or voted for it, or the governor when he signed it, of what the purpose was. But that's what was said yesterday. Assuming that was the purpose.
Yeah.
This was I'm trying to make it as polarized as I can as an example.
Yeah.
This was designed by Republicans who knew that if a Democrat got elected, if Mr. Brenovich was replaced by Ms. Mays, that there was a real risk that what Mr. Brenovich refused or found no basis to do, whatever the case is, Ms. Mays has been telling everybody she's going to go after it. So they get together, come up with a statute, and narrowly draft it so that it fits the contours of these contemplated charges.
Yeah.
That's the hypothetical. Ms. Mays would be able to achieve, as has been demonstrated by what occurred, the probable cause standard and get a grand jury to indict. If the indictment itself, securing of an indictment defeats this statute,
Yeah.
why doesn't the statute reference in the absence of probable cause? I have to read the statute that it assumes there is probable cause, but that it was in contemplation of the exercise of a lawful right, substantially motivated by, as you put it, to deter, but it also says retaliate. So
Yeah.
Ms. Mays could have been allegedly retaliating. I have to declare this statute a nullity. In other words, all of you who enacted the statute for this purpose, contemplating it, Ms. Mays, could and would go to a grand jury and could and would establish probable cause. The statute becomes meaningless because of your interpretation of it. Don't I have to assume that they intended what they intended, and if they intended finding a probable cause to be a defense, they would have said so?
Could I answer that in two ways? First, the hypothetical, and then the actual statute. And so, yeah, if under your hypothetical, if this statute was 100% written to apply to the fake electors, I would argue, well, then, yeah, I think that poses serious problems for the argument that I'm making. Whether in reality, like the actual plain language here, or in the hypothetical, you start with the plain language, and it requires the lawful exercise, and then it requires substantial motivation to deter. And I would say, you know, if we knew everyone that got together and voted, and this is what they came up with for this case specifically, then yeah, that poses problems for my argument. But that's not what we know. I'm hard-pressed to think that our legislature would pass a statute designed to allow 11 individuals to walk free of a criminal charge. I just am. Maybe I'm naive.
Or 18.
Or 18, or however many. You know, I am hard-pressed to believe that, and I'm not. I mean, one of the electors voted for the statute. So, I mean, that's a conflict of interest if that's the case. But let's put that aside.
And by the way, I am not claiming that.
No.
I'm saying that argument was made yesterday.
I've heard the argument, and if that's true, I think it's abhorrent. But setting that aside, the actual statute, if their goal was, let's just say it was, when we talk about the actual statute, then they messed up. They messed up. And you start with the plain language. And it starts with, does this prosecution involve the lawful exercise of those First Amendment rights? They messed up. They put the word lawful in. They put it in the wrong spot. And when they wrote substantially motivated, they messed up there too. Again, substantially motivated, lawful. And that's part of the prima facie showing. The defendants have to show that their actions were lawful under this statute. And again, unless you're going to invade the Supreme Court's rulemaking vote under Rule 16.4, I think you got to defer to that probable cause finding in a criminal case. And I think it's fair, Judge, to do that. Because remember, this statute is not written just for criminal prosecutions. It applies both to civil and criminal cases equally. The same language does. And I'm not saying that you have to interpret the same, because there are substantially different concerns when you have the judiciary looking into the executive branch decision-making and into a prosecution where the case has been issued by an independent judge after a probable cause finding or an independent grand jury.
In retaliatory prosecution cases, doesn't the court look to, or vindictive prosecution, whatever it may be, doesn't the court do just that? Isn't that the judiciary invading the executive branch to go into why charges were brought?
And then as we briefed, the probable cause finding weighs pretty much heavily over all those. And so, same in terms of selective prosecution, I believe so, yes. And that one, I'm not remembering entirely, but I'm pretty sure it does. And the other thing, and the other thing I think also is that this one's legislatively created, and it requires the motivation, essentially. That's what, substantially motivated. That, and you heard also that the intent of the person bringing the prosecution, I don't know how, because it's to deter, I don't know how you get past the grand jury in that setup. Is designed, the intent was to deter, because that's what motivation means. It's an emotion coupled with actions to show the motive of somebody. That's how we prevent criminal cases. And so doesn't that refer to that person's subjective intent. If the person believes that they are prosecuting the unlawful exercise of First Amendment rights, does that not matter under that definition? I think it has to matter somewhat. That has to weigh the court's analysis.
So just to reiterate what you said in a different term, if I'm a prosecutor and I express utter hatred for a specific defendant,
Yeah,
and I bring charges, I'm motivated because I hate this person.
yeah.
You're saying that's irrelevant, that I hate them, and that's causing me to file these charges if the behavior involved was unlawful behavior. It doesn't, because it has to be that motivation against otherwise lawful behavior. Am I hearing you correctly?
That's the way the statute was written. And
The way you read it.
I read it that way. So let me go back. I'll go back to the surprise example, and because at some point it has to give, and it's not absolute. I can't sit up here and tell you that, but because let's say that that case is prosecuted and the prosecutor believes there's no right to criticize the city prosecutor at a public hearing, and they're just flat out wrong. Well, then I guess so. You could bring it because I would say that matters. It has to give at some point. But in this case, I've cited for you some Supreme Court case law in our briefing. Fraud, clearly established federal law, is not protected speech. I've talked about conspiracy. And forgeries, also, the Second Circuit Court of Appeals has held that forgeries are not protected speech when coupled with intent to defraud. And that's the key. And again, this case is not just filing a false document. The indictment lays it out. Intent to defraud is an element of forgery. The jury was instructed on it, and I discussed it at length with the jurors, both in terms of charging these individuals and not charging other individuals because that intent was lacking. It is not mean, Judge.
Okay. I've heard both sides at length, but because I know lawyers, being one, there's plenty there that probably everybody in this room knows. I'd like to get a chance to answer that. And we could then go on for weeks and weeks more. I don't know that I heard anything new that was presented here that would say that there needs to be, well, we never addressed that, with the exception of any constitutional issues, which I agree nobody briefed, and we need them to be briefed if I'm going to rely on questioning the constitutionality of 12751. But other than that, can I get kind of a temperature reading on just how much your blood pressure is up, that if you don't get a chance to speak, we may rush you to an emergency room? Or not giving you that opportunity is...
Your Honor, Thomas Jacobs from Ms. Bob. I know Ms. Bob would be rather upset at some of the new allegations against her that were not in the indictment, and obviously the Attorney General's comments that she was actually in Arizona when it was actually well into 2021 when she was in Arizona. But other than that, we could rely on the...
I can assure Ms. Bob and everybody else that whether she was or was not here has nothing to do with the issue I have to decide. That may go to the sufficiency of the indictment. It may be a 12.9 issue, perhaps. But it was an interesting discussion, and I think at trial or some other stage we might have to get into that, but it has no bearing here. So you can assure her that that's not... I realize she wants to set the record straight, but the record we're making here is about a legal issue applied to this set of facts. That has no bearing.
Very well, Your Honor. Thank you.
Mr. Colombo.
Your Honor, in lieu of a oral reply, I'm just throwing this out there, I haven't consulted with anyone else, but perhaps like a 3-page written statement within 24 hours might just...
Well, if you all would do that, I would first of all really find that of great value. So but I'm always mindful when we tell people after they argue a case, well, you could do the rest of your closing argument in written form, because number one, it takes them a long time, it's very costly for their clients, and it extends the proceedings. But if you're talking about a brief summation to address these points, the equivalent of you getting the final word, then I'm all in favor of that. I would actually be most grateful if you did that, because it would allow me then to take everything I heard today and at least have, either as applied to your individual clients or to the collective, some idea about that. And I'll say, let's make it 5 pages rather than 3. And I appreciate you saying by tomorrow, but rumor has it you may catch a flight today.
Open for it. I've been wrong before.
Twice now.
Twice.
And you didn't take me up and go to the Diamondback game last night, I assume.
I didn't make it there. I had to do laundry.
Well, as Mr. Willencheck is, oh, there he is. Unfortunately, the Mets won, but we'll put that aside. Okay. Counsel,
I wonder,
can you just state your name for the record? Everybody else knows the routine.
Corey Lankhoffer for the Unique. I wonder if I could respond to a couple of points, mercifully brief, I think perhaps 8 or 10 minutes.
Judge.
Somebody want, if you want to submit something in writing, I'll read it. I'm not saying that I will give it any weight or that I won't. You're not a party to this case. I allowed it for your engagement for a very limited purpose, the unique position that your clients were in, and as I expressed. So if you want to submit something, please do, 5 pages. But with the understanding, though, that I may not accept it, may not use it for any purpose, or I might. But that'll give you your 8 to 10 minute equivalent.
Thank you.
And I know the state objects to that. I'm not saying I'm allowing it, but I did allow them to submit the brief part of it. I already commented on the last 4 pages of it, and I stick with that. Everybody is well represented and doesn't need the help of either Senator Peterson or Speaker Toma to make their case. So everybody good with that? Now, timing. I don't need it tomorrow. If you want to pick a date next week that allows you all time, you know, just catch your breath and go see what you've been missing the last 3 days. I'm okay with that. Some of you have traveled to do.
Judge, oh, I'm sorry, I didn't mean to interrupt you, I apologize.
Go ahead. Do you have an idea?
This is Stephen Binhack. I have an idea, since Monday's Labor Day, could we just do it by close of business Friday, Arizona time, and with a 5-page limit? That gives everyone just 1 day more than 1 week, given this Labor Day weekend, and probably a lot of people want to take an early Friday out.
So
They deserve it, it's such a lot of work.
a week from this Friday, as you're saying?
Would be September 6th, yes, sir.
Your Honor, may I ask a quick question of the court reporter? How quickly could we get a transcript? I'm sorry, this is Ashley Adams for Dr. Eastman. How quickly could we get a transcript from today's proceeding?
From today?
Yes, Your Honor. Sorry to put you on the spot.
Yeah, you're kind of putting me on the spot. I don't know. Maybe by Monday.
Monday's a holiday.
So I sent emails to everybody if everybody wants to.
We don't want to ruin your weekend.
What would be a reasonable time for you, today's transcript, not all 3 days?
Judge, the FTR is still there too.
You could secure the FTR instead of the written transcript. And that, we can get you information how you can get that much more quickly. Would that work?
Yes, Your Honor.
Okay, so we're not going to impose on our court reporter yet. Okay.
And just, I could get it to you by Monday.
You could.
Monday's a holiday.
You're going to give the true definition of Labor Day.
Right. I could get it to you at the latest, I can get it to you. Whoever.
Thank you.
Okay, so assuming you have it on Monday, it's next Friday, September 6th, the reasonable deadline. Everybody seems to be in agreement, so we're allowing, and the question then becomes, really, what is the state being asked? They would get the final word on the argument, it's their motion. So I would say you could submit something in response to it, but only if you can show that they've raised an issue that isn't part of what's already been argued. They're really responding to you. So I don't think there's any deadline being put on you to do anything. Unless there's something you want to sum up with next Friday, I certainly will accept it, but
Judge, I don't know if that's going to be possible. If I could sum up something, if I have the possibility, I'll see. And I would comply with the 5-page limit. I mean, there was a day and a half of argument. I had an hour and a half. I don't think that would be unreasonable.
okay, but does concern me about the slippery slope of you then raise something that they didn't contemplate. But I'm going to leave it to you. You're not required to submit anything, nor is anyone else. But I'm going to put that order will apply to you as well. And if you can think of something that needs to be expressed, then when I get it all, if there's something raised by that others have an issue with, we'll figure out how to address that. And hopefully at some point this hearing will come to an end. But I don't have any criticism of anybody that this took much longer than anticipated, because you all have been, as I said yesterday, really incredible in your presentations and have been very patient with my questions. I think you all know where my struggle is, and the struggle it is because this is a first impression. I think we all agree. It's a statute that was recently passed. It's a statute that has terms in it that are not defined by the statute. That doesn't make it unconstitutionally vague. It's just we have to look elsewhere. And we have different interpretations of how the statute should apply. So it's always going to be the burden of the first in the room is going to always have the challenge that others later won't. But I guess we're all in that first group, and we take it on with the same loyalty that we take on our responsibilities, and I will do my best with it. I normally rule quickly, promptly, I should say, not quickly. I think you all can appreciate that this may be an exception to that. So, but it's not yet under advisement, obviously, until all those briefs are submitted. So I assume I'm taking it under advisement as of Monday, September, 9th? This matter would be taken under advisement unless something is raised in these other pleadings that require further briefing or us discussing it. The other thing is, as a group, I am very mindful of how expensive and time-consuming it is for us to collect together. There may be some procedural issues that everybody agrees, gee, we could use some guidance from the court on this particular issue. If you all as a group agree, or as pockets of the group, because maybe it applies only to a certain set of defendants, that there's an issue that if we could chat, it would avoid lots of additional litigation. Please, as a group, whoever the group is, email my judicial assistant saying, we all agree that if we can get 15 minutes, it's going to save us hours of work. My JA will then set a virtual hearing and get it on the calendar as quickly as possible. I told you on Monday, and I repeat again, part of my job, aside from the obvious parts, is to help you do the work that you're doing, and I would like to continue to facilitate that as best I can. And we'll go from there. Just a question. Is Mr. Pacheco here?
Yes, Your Honor.
There you are. My JA has been trying to reach your office about something that was filed.
Yes.
Can you just make sure that you talk to her?
Happily.
Thank you. I don't want to get into it any further than that. I think you know what I'm talking about. Or you might?
I do.
Okay, thank you. Other than that, then, are we all ready? I know we're going to miss each other, right? This has been. But are we all ready to go back to, you can go back to your regularly scheduled programming? Great. Thank you all.